please write to us in the chat, and Susie and I will help with that. If you have any tech issues, though, you can write OGR Tech. If you go into the participants tab, you can find OGR and ask any questions that you might have on the technical side. So thank you again for joining. A little bit of background about who the Office of Government Relations is. So OGR represents the policy priorities of the Episcopal Church, the U.S. government in Washington, D.C., and aims to influence policy and legislation on critical issues by both highlighting the voices and experiences of Episcopalians and Anglicans globally. All policy positions are based on General Convention and Executive Council, which are the legislative and governing bodies of the church. We regularly host these types of events called A Closer Look with OGR on topics of interest related to those of you who are part of the Episcopal Public Policy Network. We also host weekly network calls where we talk about these kinds of issues and more on Thursdays from 1 to 1:30 Eastern time, if you ever want to join those. A lot of folks have really enjoyed going to those, and we enjoy giving them. So we are so glad to have BJC joining us today. OGR works with BJC, or the Baptist Joint Committee for Religious Liberty, on a number of issues, and we are especially grateful for the partnership. BJC leads work on Christians Against Christian Nationalism, a project that the Episcopal Church is a part of. And of course, we've worked with them on issues related to religious freedom, but also issues like Oak Flat, a key Indigenous issue as well. But I will not be moderating the conversation, so I'm pleased to introduce you to Mary Kostel, Chancellor to the Presiding Bishop, who will be hosting and moderating today's event. Mary was appointed Chancellor on January 1st, 2019, a graduate of Princeton University and the University of Virginia School of Law. She's clerked at the federal level, served in the U.S. Department of Justice, and practiced in Washington law firms, where she's represented the Episcopal Church in various matters. So Mary, thank you for hosting this conversation for OGR. I'll hand it over to you for the remainder of the webinar, and look forward to it.
Thank you so much, Lindsay. Good to see everyone here, especially my friend Holly Hollman, who I am delighted to introduce. Holly is the General Counsel and Associate Executive Director of BJC, and she provides legal analysis of church-state issues that arise before Congress, the courts, and administrative agencies. Holly also serves as Adjunct Professor of Law at Georgetown University Law Center, where she co-teaches a course on church-state law. She earned a BA from Wake Forest University and a JD from the University of Tennessee College of Law, and brings a wealth of experience to the topic that we're going to tackle today. So, Holly, hi.
Hi.
Hi. This was a significant term for the court. We're talking about the Supreme Court of the United States, of course, on a number of issues, but including two really significant cases that addressed religious liberty. Now, BJC, of course, is regularly involved in religious liberty advocacy, including leading amicus briefs at the court, and was involved in both of the big cases that came down this term, deeply invested in understanding and helping us understand what these cases mean. So, of course, the Episcopal Church and our Office of Government Relations have an obvious interest in religious liberty as well. And these two cases are really helpful in pointing out some of the complexities in this area of the law into distinct cases that sort of come up in different contexts. Tell us something, Holly, about generally about the religion clauses in the Constitution and how they protect religious freedom.
Well, first of all, let me say thank you to the Office of Government Relations. Thank you to Lindsay and Susie and Rebecca for all your work ahead of time, and for inviting me to be with you. And it's always a pleasure to be with my friend and colleague, Mary, who does such a wonderful job and such a fantastic lawyer. And so it's a great time when we get together and get to share notes. So thank you for having me here today. Yes, I think it's important to start to think about what did the court do in the area of religious liberty this term, among other areas where the court made a big impact. Sort of think about how religious liberty is protected and the kind of complex way that the Constitution protects religious liberty in a very specific American way. Our legal tradition that is sometimes referred to as the separation of church and state, or we talk about religious liberty being our crowning jewel in America. We know that it's special, but why is that? And it's because we have this language that comes out of our history that the founders put together that has two clauses, the two religion clauses, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So religion is singled out in a special way in that First Amendment. It was also noted in Article 6 with the no religious test for office clause. You know, the founders came together and they treated religion in a special way, and it was a brand new experiment. So that's kind of the background to be thinking about these cases. They develop often as free exercise cases or no establishment cases. And in recent years, in the last couple of decades, I think it's fair to say that the court has not been as interested in a fulsome view of establishment, and there's been a lot more activity on the free exercise side. So that's how we kind of start this term, thinking about this. And you have two cases that we'll talk about that come out of two areas, two issue areas where a lot of church state law has been made, and that is government funding. So funding programs that interact with religion or religious institutions, and then religious expression, prayer cases. So we have a prayer case. So that's another significant thing about this term, is to have, you know, two big cases in this area of law. Again, we think about these clauses as working together to protect religious freedom. That's BJC's perspective and a common perspective. But at the same time, we recognize that a lot of the cases sometimes talk about the tension between them, and we can see that tension. And we definitely can see that in the court, and the courts dealing with the clauses.
Thanks. Tell us first about the funding case, Carson versus Macon. Can you tell us about the facts?
Sure. So the funding case the court took this year, a case called Carson v. Macon, comes out of the state of Maine. And it was a case brought by parents that challenged the state of Maine's system for providing public education. Maine is a very rural state, at least parts of it are very rural. And so in addition to school districts that have their traditional public schools, some school districts do not have public schools, and instead they contract with private schools to meet the state requirement to provide all children with a public education. And then in a small number of those districts, they don't contract with a specific school, but parents are allowed to choose among approved private schools in order for the state to meet that obligation to, again, ensure that all kids, wherever they live, have access to a free public education. And part of the criteria for participation in that program is that the schools be non-sectarian. That's the way the Maine law was drafted and intended to ensure that they were. The idea is to provide, you know, as much as possible, the equivalent of a public education. And of course, in constitutional law, in public schools, the public schools do not indoctrinate students with regard to religion. They can teach about religion, but the public schools do not advance religion, do not lead in religious exercise, or teach religion from a devotional standpoint. Well, these parents sued, saying that that restriction on participation in this program was unconstitutional. They said they had a free exercise right to send their children to the private school of their choice, where the district did not provide for a public education. So that's what went to the U.S. Supreme Court. The parents lost in the courts below, but made it to the U.S. Supreme Court under this theory of sort of equal treatment, that they should be allowed to send their students at government expense to these schools that provide explicit religious education.
And what happened?
Yeah.
What happened?
So what did the court hold?
Yeah.
The court held by a 6-3 decision that that the state of Maine's program as excluding sectarian schools was unconstitutional. The basic holding is that in this program, and very important to the understanding of the court is how this program worked, that the state, this court found that the state had chosen to have a program that would subsidize private education, and that in a situation where a state subsidizes private education, that it could not exclude private religious education. The big issue, of course, big question people want to know is like, does this mean states have to fund religious schools? Well, I think it's going to depend on the context. And just to back up a little bit, you know, when I was talking about the Establishment Clause being one of the two ways that we protect religious liberty, of course, that is about the government not funding and sponsoring religion itself. But 20 years ago, in the Zellman case, the court had approved a system of an education program where there was a system of what they called true private choice. In other words, a voucher system where there were choices to be made by the individual who received the money, and they could apply it at a variety of different schools: private, secular, private, religious, and things like that. So the court had already said that that was permissible under the Establishment Clause, that kind of program was permissible, but had never until this case said that that would be required. So that's the big deal about this case, is that if there is a program that could conceivably be seen as producing some kind of choice for individuals in the setting, that then the state could not exclude the religious choices. So before that, you know, I don't think there are many programs like the one in Maine, but at least there was that idea that you wouldn't accidentally have to fund private religious education.
And do you think that the fact of individual choice here was so critical? So for example, in those districts in Maine where the school district did contract with another school, rather than handing the parents the funding and letting the parents decide, and let's say the only other school in, you know, rock throwing distance or whatever, in reasonable distance, was a religious school, could the argument now be made that the local district had to put the funding there?
I think we don't quite know that yet. I think it was important to this case that there appeared to be some choice, whether Maine intended or not. They didn't mean it to be a broad choice system like in the Zellman case. They thought they were just finding alternate ways to provide a secular public education. I don't think the case goes so far as to require direct funding of private religious education, though the case is really concerning because the court does not at all talk about the difference between private religious education and public education. And there are many differences, but the one that's significant from a constitutional perspective here is that religious neutrality that we expect from our public schools. Public schools that serve 90% of the population are required to be religiously neutral. They can teach about religion, but they don't indoctrinate in religious matters. There's individual religious expression, but not school sponsored, which we'll talk about in the next case. So the damaging thing from our perspective, or the worrisome thing, is that the court did not make clear, and in fact, really glided over the differences between religious education and secular education. It did come up a bit in thinking about what regulations will follow and how these schools are operated. Many of the private religious schools discriminate in their admission standards. They, are, as Justice Kagan said during the oral argument, they are proudly discriminatory. And so, that's good. That is a conflict that will have to be resolved in the future cases, whether or not that would ever be allowed, with the government funding.
And do you think there's room for a state like Maine to more thoroughly prescribe what public education should be and shouldn't be, and that be constitutional? In other words, that admission can't be discriminatory on X, Y, and Z basis, or curriculum has to be X and can't be Y?
Yeah, I think that,
as long as it's equally applied to the public schools and all the other schools.
Yeah, I think that we don't know. It would seem so. I don't think this decision says that they cannot do that, but I am concerned that this court might not find the general rules for non-discrimination apply the same way to religious institutions. And I say that based upon how the court has ruled in other cases. Noting, leaving room, a lot of room for religious exemptions, for treating religion differently in some areas, while moving toward treating religion the same, in equal terms when it comes to receiving the benefit.
Interesting. You mentioned in your opening comments about religious freedom generally and what the Constitution protects, an idea of separation. Do you see this case as implicating what we have understood to be kind of a wall of separation that the religion clauses provide? Is that wall being disassembled essentially?
Yeah, it's a good question. The wall metaphor is thrown around a lot, and it means different things to different people. But I would always assert that there is some separation that was intended by looking at those clauses and religion being treated differently. And I think you can see it in actually both clauses, but primarily people talk about it in the Establishment Clause, and they think of the Establishment Clause creating this separation to make sure the government is not active in religious institutions. And I do think that this is another step by this court of not upholding that kind of separation. In fact, if you listen to oral arguments in this case, you'll hear a lot of comparisons to religion being just like teaching, or just like a book club or a soccer club or something like that. They were just saying, like, schools do different things, and of course that's normal and that's what you'd expect. And it really denigrates the idea that religion is treated special in a way that recognizes that the government has limited authority, capacity, competency in matters of religion, which I think was one of the founding ideals that led to the Establishment Clause, and that has been beneficial to religious liberty in our country.
Thank you. Let's turn to the other big case, that Kennedy versus Bremerton. Can you tell us about the facts in that one?
Yes. Kennedy versus Bremerton is the praying football coach case, if you guys have heard of that. It comes out of the state of Washington, and it was a long-standing employment dispute between a high school football coach, assistant football coach, and the school district. And it came to the Supreme Court, brought by the coach who had lost in previous rounds of litigation, the district court and the appellate court. He argued that he had a free exercise and free speech right to pray on the field, on the 50-yard line, immediately following the football games. Well, I said it was a long employment dispute. He used to have a regular practice of inviting the students to join with him, the players on the field and the other team on the field. He also had been regularly engaged in religious kind of speeches with the team after the game, including in the locker room. When the school found out about these activities, it kind of, it addressed them with him to say, we need to follow the policy. The school policy is that teachers do not encourage or discourage religious activity, which fits with a long-standing rule of how we protect religion in the public schools. Individuals have the rights, but the teachers, the school itself does not promote or denigrate religion. And Coach Kennedy, I think, immediately went on Facebook and says, I think I just got fired for praying. I just throw that one fact out there to just show that this case lit a sort of firestorm over the facts and who was mistreating whom. He's a contract employee, so they were trying to work things out, and actually he was eventually put on paid administrative leave while they were trying to work out, could they accommodate his need to pray while at the same time protecting the school's interest and not advancing religion, not endorsing religion, which is the standard that the court below had applied. But they weren't able to work it out. He insisted on praying at the 50-yard line right after the game. And this case went all the way to the Supreme Court. The court ruled again, 6-3, breaking down on these conservative liberal lines here, and held that Coach Kennedy was within his free speech and free exercise rights to pray. And the court, what's so striking about this is that the court focused only, not on all the history, the facts that I just recited, and you'll see in the dissent, but just on what he did at the end of the dispute, which is that he continued to want to pray on the 50-yard line. He called it I think it was a brief, they called it brief, private, personal prayer. I don't know how it can be private when it's on the field at a certain place at a certain time, but personal in his own capacity. The court upheld that right, ignoring all the other factors that came with that. The important thing about this case from BJC's perspective that we were very interested in the brief that we filed was to remind the court that all branches of government had long recognized distinctive roles between individuals and the government itself. And in the public schools, the rules have long been established that see those roles differently. So that, of course, a teacher there'll be certain aspects, certain times where a teacher is acting in a personal capacity, but it was hard to see that here, where this was part of a long tradition of a coach on the job immediately after the game, involved with the students, doing that. We thought that would fall on the other side of ensuring that the government itself does not advance religion.
Tell us where do you see coercion fitting into the court's understanding of the situation here? I mean,
yeah. Well, people might ask, well, what's wrong with that? People would ask me, Holly, you're a religious liberty lawyer, aren't you for people praying? Of course, we're for people praying, but understand that a teacher, an administrator, a coach is in this government capacity, and they can't advance religion, or it harms the individuals, right? So a coach who prays with his students or in that capacity will certainly have an effect on those players. And coercion is one of the things that the court has long been concerned with in upholding the standards for religious liberty in public school cases, in holding in the graduation prayer case or the school football prayer case. These are two cases that the court mentions in its ruling. Those cases, one of the concerns is that the schools not be used to coerce students in religious matters. Importantly, I'd say, even though this case was disappointing, it's disappointing that the court even took this case, but and it was disappointing in how they ruled. I will say that importantly, the court said that it would be different if there was evidence that students were coerced to pray with a coach. And in the facts that the majority accepted, that was not part of the factual record. So this decision should not at all be interpreted to sanction coaches, teachers, principals leading students in religious exercises, inviting them to participate with them in ways that I think are fundamentally coercive. And the court has always recognized that that is a coercive environment. Just public schools, education is compulsory. They're there to get their education, and anyone who played sports or is a parent of sports kids knows that a team environment is inherently coercive, and you would not want to introduce religion into that.
One of the things that I found interesting, and you and I chatted briefly about it, was the different portrayal of the facts in the majority opinion versus the portrayal of the facts in the dissent. If you read the majority, you get the sense of a very private moment that the coach is having, and again, not coercive. And then if you read the dissent, it's an entirely different scenario. First of all, that points up how important actual facts are to these decisions, wouldn't you say? The context really matters, but also, do you have a thought about what's going on with that kind of factual disagreement?
I think it's unfortunate that when I said that the court they should not have taken this case, I have to say that as a court watcher, observer of this in this area of law, I didn't there was no reason to take this. There's not a lot of, there have not been a lot of conflicts like this. There are typically conflicts about, school events and things like that. And there's pretty clear law on that. And so it was disappointing. It sort of, I fear that it fits in a certain political narrative that some members of the court have kind of taken on, that establishment clause restraints on government action and religion are somehow hostile toward religion, when that is not at all, I don't think is all true or necessary, and certainly not a helpful frame in trying to resolve these kinds of conflicts. So I think that's really how I see it. The court has long complained about establishment clause standards, or there's long been debates about establishment clause standards, but that's because it's a complex area of the law. And no one theory works perfectly to resolve all the cases, the religious expression cases, the funding cases, the display cases, and the courts always use these different standards. But there was from the conservatives on the court, there's been a lot of attack against some of these standards as hostile toward religion. And I think that's kind of what they use this case to say. It's like the establishment clause doesn't go so far to prevent this. And that's sort of the track they were on. And, I don't think this case would have ever come up if the only thing that had happened as a coach or a teacher after an event, without any regard to the students, really was involved in a personal, private act of religion. Instead, as I said, this came up in a way that showed some desire to, do this in a public government sanctioned forum. And we hope it'll be interpreted according to the facts that the majority selected. And I would advise any school district and teachers and parents to keep that in mind, that the court said, that the court understood that if he had continued to invite students to pray with him, that that might be still unconstitutional, because it would be inherently coercive.
And when you talk about former standards and all the different standards that are used in these different religion cases in these different contexts, the reasonable observer standard was essentially what seems to have been abandoned here, right? So would a reasonable observer up in the stands have thought that the coach was speaking or praying on behalf of the school district, right? And
that's right. There's these standards. Some of you all may have heard them talk about the Lemon test. The Lemon test requires that a government action has a secular purpose, at least it does not have a primary purpose or primary effect of being religious, of advancing religion. And then sort of another kind of twist on that was this endorsement test that Mary's talking about a reasonable observer. In other words, does the government action lead a reasonable observer to think the government is kind of taking sides in matters of religion, advancing religion, sort of separating categories of political insiders and outsiders based upon religion? And that was the test, the endorsement test, that the court below had applied. And so, people can fight about all these tests. And I think the way you just described it, Mary, is the way some people would see it and say, well, wait a minute, if I just see a coach praying by himself, I don't think the school's endorsing that. And I think that could be fair. And Justice Gorsuch, you could say that, but you do have to ignore a lot of past practice. And I am concerned that the court was not thinking about the pressure of that are on schools, and thinking about how the schools have to maintain control of their teachers and their messages on all different matters. And why on earth would you try to restrain schools and not allow them to do so in matters of religion, an area that can be so fraught and so divisive?
Okay, I think we're going to see if we have I'm going to ask you one more question and then wait for Lindsay to send me some questions from our audience. What you've told us a little bit about what you see, what might be coming up in the funding context, what might be coming up next in the funding context. So the Carson context, but what do you see, what might be the next big issues, if there are any, after Kennedy in the sort of public prayer? Do you see anything immediately on the horizon, or do you think things may be quiet for a while?
Yeah, I think what I fear is that there'll be confusion based on this last thing that we were talking about what is the standard. And that is because the court said we should look to historical understandings of the Establishment Clause. And that doesn't provide a lot of guidance. Obviously, there were no public schools in the founding era, and then the history that we do have in public schools, came a long way toward this vision of religious liberty that we wanted, which is, all students are welcome without regard to religion, but the school itself doesn't advance religion in ways that would divide citizens based upon religion. So, I'm not sure what the next, if we'll see more religion in public school cases. I think it'll depend on, I think the real problem will be on the ground in different communities and how this will be interpreted. And I would put this plug out to all of you, who I assume you're from across the country, and many of you, I'm sure, support your local public schools as good citizens. And I think understanding that you want your schools to continue to serve all students fairly, and that this case should not be seen as allowing any teacher to use their classroom or their field to advance religion on behalf of the school.
Here's a question that's come up in the chat: is do either of these cases say anything about books, the banning of books, the control of the state over what children read in schools, or what's available in public libraries?
I think it's just again a curious time to give more power to the government to advance religion when you're seeing states pass laws to restrict, that they don't trust. We're seeing a lot of distrust of public schools, distrust of teachers and education, and yet we're going to trust them with our, with your religion when families make very different religious choices about the communities that they're involved in and their the way that they practice. I think that that's a real concern.
What do you think? Here's another question. Do you think these decisions, but even other decisions that have come down this term, and this is a big question, will influence or may predict how the court approaches LGBTQ discrimination questions going forward, and particularly with how they interact with religious liberty?
Well, it's what we have seen is that even in the cases where the court has upheld or expanded LGBTQ rights, they have left room for religious differences. Recognizing that there are religious differences, particularly about sexuality and marriage, but also really leaving this room. I think, leaving some room that might limit LGBTQ rights based upon religion. I think we're going to continue to see these kinds of disputes in various contexts. We've seen them in the commercial context, and we've seen them in the government contracting context, and there's more coming with a case next term. So yes, people will make religion claims to get out of non-discrimination requirements, and I'm sure that we'll continue to see more of that. I think one thing that's been noted by a lot of people in the media, and we felt it here in our work, is that this is a court that's very interested in religion cases, and that in all cases the side that is seen as representing the religious side has been winning. And I support religious freedom for all, But the establishment clause and the government side sometimes is the right way to protect religious freedom for all by having equality standards and non-discrimination standards across the board in certain contexts has often been, and I maintain is often the best way to protect religion. But I don't see the court going along that route.
One of the another one of our audience has made the point, wondering if the outcome in the Kennedy case would have been the same if the coach had been of another faith, a Muslim or some minority faith in the United States. Yeah. One does wonder things like, I mean, the text of the opinion would say no, but
right. That's right. Well, and again, that's how I think this case is going to be really important, in that it's going to be used different ways in different communities, and it's going to be read different ways in communities. And we know, as was mentioned earlier with our work against Christian nationalism, that in many parts of the country, in many communities, there are great political forces that really will see this as an opportunity, a justification for having more government influence and pressure from a certain Christian perspective. Like you said, Mary, on its face, it's not, the decision shouldn't do that. But I think, we know this, this from talking to religious minorities. What is their experience in a school setting with a Christian teacher or coach who feels the need or misuses, and I'd say misuses their position to coerce people in matters of faith, or send the signal that some kids are outsiders because they're not part of the same Christian community. And I'm concerned about that. This case won't help.
Someone has asked a great question. So well, they're all great questions. This one, you and I have spent some time talking about this one, which is how do Supreme Court decisions get changed? In other words, what's the basis for one set of 9 justices to abandon an old standard like the reasonable observer standard, or we've seen this term, the overruling of Roe versus Wade, big changes in precedent. What are some of how does that happen? Someone asks.
Yeah. The way we think of it's supposed to happen is it's not. It's just like a new factual case comes up and you're just applying it to a different situation and kind of tweaking. And, we have this idea that only the hardest cases make it to the Supreme Court. But what we've seen is a change in the court personnel has had a change in the court's view of certain standards to apply in these important issue areas. And so, tests can come in and out of favor. And perhaps, in the Establishment Clause area, you had an earlier case where history and tradition may have played a more legitimate role when it came to prayers before legislative meetings. There was a case called Town of Greece versus Galloway, and that's where the court first said, we're not going to apply the limit test. We're not going to apply the limit test. We're not going to apply endorsement. That we know there's a history of legislative prayer that goes back to the beginning of the founding era. So we're going to uphold this, even though the context is very different. This was in a town council meeting where people go before their government to ask for specific things, and then they're going to have a prayer as part of it. So that's a case a few years ago, and then that sort of leaks into the next case as you have a group of justices who frankly don't see the same value and its high standards for the Establishment Clause that earlier courts did.
And this would obviously not be the first set of 9 justices who or not 9, but this particular majority that overruled precedent. I mean, the Warren Court overruled precedent, right? With Brown, got rid of Plessy. So it's not the first time. It's just an interesting set of factors that makes that happen, historical factors. And
a lot of conversation academically, right, about what's appropriate, what role should history play? Can you discover the original intent? And even if you can, which some say you have to, you must, then how do you apply that in a current context? So these big debates, academic debates, are playing out, and they are influencing, people's rights day to day. And when people say, oh my goodness, everything's so horrible, and how do you find hope? The one hopeful thing I can say is that people are paying attention and trying to understand, and thinking about what can they do in their communities and in their personal capacities to stand up for religious liberty for all in ways that are important, apart from what the court does.
Let me put a plug in for a great podcast that you do with your director, Holly. With your director, Amanda Tyler, called Respecting Religion. I think you had a session recently on the Kennedy case. So folks, check that out. There's so much thinking and talking going around these issues now. Someone has asked, to tell us a little bit more about your work to counteract Christian nationalism.
Yeah, and if you don't know about that, let me tell you the good work that your denomination is doing, because Bishop Curry was one of the main early embracers and endorsers for us of this project, which is really a group project, ecumenical project that said that was an effort by Christians to stand up against Christian nationalism, all kinds of horrors that people can learn about Christian nationalism. But from BJC's perspective, it's a direct affront to the kind of religious liberty that we think this country has always stood for. And, it's kind of the best of our tradition. So we started this project, Christians Against Christian Nationalism, and lots of different denominations have been involved. It's really a grassroots effort. Individual signers just sign a statement of principles. They're pretty broad-based principles that most Christians and most Americans can agree to, and the signers so far attest to that, because we have people from Christian communities of all different kinds, people that may not agree on many things in Christianity, but agree that Christian nationalism, is a major affront to the idea, to any understanding of Christianity, and a major affront to our democracy and the vision that we can be equal citizens without regard to religion. So you all have been an important part of that. If you don't know about it, please go to the website, Christians Against Christian Nationalism, read the statement. If you like it, sign and join. There's very little that is asked of you, but there are numerous good resources there that could help you have a good conversation in your community with your Christian and your non-Christian friends, who would certainly support and be happy to see your efforts there, because we've learned that as bad as it is for the Christian witness as whole, that it is, harmful at times, potentially, at times deadly for those who are religious minorities and non-Christians. And that's this, this political ideology that, advances, that kind of merges Christian and American identities in very harmful ways.
This is a connected question, perhaps, because I think what you're talking about is something that's happening in the culture. This is a question about the court. And the question is, are there legal principles for when two opposing religious beliefs clash? So, the different religious views about same-sex marriage. And the question is the Supreme Court endorsing or giving preference to one view over the other?
Yeah, so that's really important. In this group, it's good to remind you that, because your OGR is all about advancing policy that comes out of a religious tradition, but also matches with other policy interests. So it's important to remember that all laws reflect some kinds of, moral judgments, but we have traditionally been a country that doesn't pass religious laws that are explicitly and only about advancing religion, or that reflect a narrow religious perspective, but instead serve all people. So while it's not always easy, obviously people can have religious motivations from two different sides on the same issue. It's not hard to come up with examples about that, and that's why we know that that people, religious voices must be welcome, religious and actually, I think it's principle number 1 in the Christians Against Christians Nationalism statements, that people without regard to religion are all welcome and responsible to argue their positions in the public square. But it's not the government's job to make religious laws, advance particular religion, and it's not always easy to figure out where that line is, and that's good, hard work for us to do. We want to respect religious freedom for all and respect those religious differences, and leave at least our primary religious activity, how we worship, how we train each other, our kids in religious education, how we proselytize and share the faith, to the private sphere and to our faith communities, and not have the government itself advancing religion.
Well, Holly, this has just been terrific. We thank you. We could go on probably for another hour, 45 minutes.
I'm sorry, I can't. I'm sorry. I see there's an active chat, and I look forward to at least learning from all of you and your good questions, even though we couldn't address all of them in this time. So thank you all.
Yeah, wonderful. Good to see everyone here. Thank you to OGR for hosting this, and real delight to be with you. Holly Hollman, everyone. Give her a silent online hand.
Thank you. I'll keep up the good work too.
Thanks all.